Now we are going to study revocation of proposal and acceptance. Now we are going to study how and when the proposal made by the proposer and the acceptance made by the acceptor can be revoked. Now this acceptance and this revocation of proposal and acceptance is governed by Section 5 of the Indian Contract Act. So a proposal can be revoked at any time before the communication of its acceptance is complete as against the proposer and not afterwards. Like a proposal can be revoked by the proposer any time before the acceptor or the person to whom the offer has been made accepts the proposal and that is against the offeror. Like A makes an offer to B and B has accepted the offer in his mind. So in his mind it stays. But A doesn't come to know. So it must be, the acceptance must be complete as against A. That means as that the acceptance can be understood by A. Because if it is in his mind, A cannot say that B has accepted because he has accepted in his mind. Like for example, if B, A sends a letter to B to sell his real estate property to B for X rupees. Now B posts a letter back to A. Now before posting letter back to A, because if he has this intention of accepting the offer in his mind and he has accepted the letter mentally, but it is not against A because A cannot read B's mind. So, but if B posts a letter from the very moment when he has posted the letter, irrespective of the letter has reached A or not, once B has posted the letter, so this means that he has accepted, but as he has accepted, now A cannot revoke his offer. This is because now according to A, the acceptance has been made. Now why when he has posted the letter and why not when the letter has reached A? Because if he has posted the letter, then it will bear some stamp from the post office. It will bear some sort of date from any authorities. So then A can claim it, that he now can understand that acceptance has been made. If A cannot understand and B has it in his mind, so it makes no difference to A because A cannot claim it in the court of law and law cannot recognize it even if A somehow comes to know. So it should be, acceptance should have been made according to A. So we are discussing it with respect of the offerer. So if acceptance has been made according to the offerer, when offerer can claim it, from that point of time offerer cannot claim revocation of the offer because acceptance has been made according to him or he can claim it. Now when can acceptance be revoked? Acceptance can be revoked at any time before the communication of this acceptance reaches the offerer. Like in this case of A and B accepts to buy the real estate property of A for X rupees. Now, and he posts a letter to A. Now, if the letter of B has already reached A, now B cannot revoke his acceptance because his acceptance has been complete according to A and B as well, because A has received, he has come to know, and B also knows now that A has come to know because there will be a date on the letter when he receives, there will be a stamp when the postman goes to deliver the letter. If it is a registered post, there will be a date when he receives the registry. So this way, because A has received it, A has come to know that acceptance has been made, now B cannot revoke his acceptance as well. So this was regarding proposal and acceptance revocation along with illustrations. Now, when we can say that a proposal stands revoked. So a proposal, now if you have to revoke a proposal, you can do it by communicating it to the other parties. Like if there is an offerer and he wants to revoke or terminate his offer, so he can send a notice to the other parties, like he is now revoking his offer. Of course, there can be legal consequences and there can be claims and counterclaims. That will go on further. But on interim basis, he has revoked his offer. So the same way for other instances as well. there can be legal repercussions, but on interim basis, we can say that the offer has been revoked. Now, the other way is like if the acceptor fails to fulfill the condition preceding acceptance of the offer. Like if there is a general offer, we can take this illustration, like anybody can apply for this job. So there is an offer of job. Now a person applies, but he is not BA pass, he is merely intermediate, 10 plus 2, but he is not BA pass. So for him the offer is not valid. So it will be said that offer has been revoked. Though it is invalid, not revoked, but this way it has been revoked for him. Now the other way is on the lapse of a specific time period cited in the offer. Like in an offer, if you are placing an offer to someone and you mention a specific time period that the offeree needs to respond within this time frame, and the offeree does not respond, so the offer becomes time barred. So under those circumstances also the offer gets terminated. And there can be a justifiable time period also, like if an offer has been made and a justifiable time period has passed and the offeror is not getting response of the offeree, so it will be taken as that the offer has been revoked, because if the respondent is not responding, so the offeror cannot wait for infinite time period. So there has to be some justifiable time period. Of course, there are no rules laid down for justifiable, because it is merely a word justifiable and you need to justify it before the court of law. So you need to prove your competence to prove to the court. You take references of previous court rulings, and you also try to prove it with the help of other circumstances, with your knowledge, whatever you have got. You try to prove it logically, that court may issue fresh rulings as well. So these things go on, but on interim basis, under these circumstances, you can say if you are an offeror and you merely make a claim that a justifiable time period has passed. Now it can be 1 month, it can be 1 year, it can be 10 years. When you understand that it is a justifiable time period and it has already passed, you can claim that the offer has now been revoked because you are not getting response within a justifiable time period. So it depends upon the offeror when to claim. But counterclaims can always be made, that's another thing. But on interim basis, when the offeror thinks that a justifiable time period has expired, so on interim basis it will be considered as expired. Now the other situation is on the demise or lunacy of the offeror. Like if the offerer or the proposer or the person who is making the offer or proposal dies or turns lunatic or mad or insane. So under such circumstances also his offer stands revoked, but such knowledge of his demise or of his insanity should have been made by the acceptor before accepting the offer. Like if the offeree has not accepted and he has come to know that the offerer has died or has turned lunatic, so then he can claim that or the anyone on the part of the offerer, like his descendants or whosoever is the successor, can claim that the offer has already, you can say, expired or revoked or terminated. So this claim can be made under those circumstances. But if the offeree has already accepted it and then he comes to know of the death or even the insanity of the offerer, then the offerer side or his descendants or dependents or whosoever succeeds him claims that okay, but he has accepted, he comes to know everything, and now the successor of the offerer is claiming that he will fulfill all the conditions that those were laid down in the offer by the offerer. So, and he is a legal successor or they are legal successors. Now they will be fulfilling it. Like you can take in the case of individual as well as any organization like a company. Like if a CEO has made an offer and he has expired or he has turned lunatic, a new CEO comes in, so he will be taking over the charge. So he can claim that the offer has been valid because the offeree has come to know it later, and now he is taking charge. But before that, new CEO has also not come in. The previous CEO had died, and there was no one, so offeree could have claimed that, or other people, even on the part of offeror, could have claimed that the offer has been terminated because our CEO has died or our CEO has turned lunatic. So these can be the situations. There can be any number of situations. Anyone can claim. Both the parties can claim in their own interest, but these can be the situations. Now, state amendment. There has been amendment in the section 5 of the Indian Contract Act in the state of Uttar Pradesh, via Uttar Pradesh Act 57 of 1976, and this amendment says, when an invitation to a proposal contains condition, like if there is an offer, like if there is an offer, you can say, or of course it is an offer when you are soliciting offers. If you are soliciting offers from any party or parties, and you have laid down a specific time period that those parties should place their offers within that time frame, like within 10 days from this date, like or they can specify the date as well, from 1st July to 10th July 2022. Anyone can make offer to me, and that person has not made between this time frame, and it has now been 11th of July 2022, and the offer reaches you, or the offer, according to you, when there is a situation when an offer has been made, then you can claim that such an offer can stand or stands terminated or is invalid because it is time barred. You have invited. Now he is not making on his own. You have invited the offer, but you have invited the offer between a time period only, and the offer is not reaching you within that time frame. So you can claim that this is not a valid offer, or this offer stands already terminated. So this is the situation in case of the state of Uttar Pradesh, Uttar Pradesh Act.